and Commercial Institute presenting shorthand dictation, legal and journal passages for upcoming SSC, PSC, Rail, High Court, District Courts exam at the rate of 80, 100, 120, 140, 160 and 200 words per minute. For acquiring 120 and 160 speed in a very short time, you should follow these guidelines. Practice this dictated passage 4 times at a stretch in a day. Practice each outline before taking dictation thoroughly and transcribe and check your transcription from dictated passage which I dictated in this video. Let's start. I have perused the judgment proposed to be delivered by my learned brother and agreed with the same. However, I intend to add the following views. Para. At the very outset, I refer to the arguments made by learned counsel for the state, Mr. Mukherjee. He submits that the writ petition is not maintainable as the writ petitioners have claimed themselves to be state government employees, and in view of the provisions contained in West Bengal Administrative Tribunal Act 1995 and the decision of the Honorable Supreme Court in the case of L. Chandra Kumar, the State Administrative Tribunal has the jurisdiction. According to Mr. Mukherjee, the writ court cannot be the court of first instance in case of the disputes of the state government employees, as they are to exhaust their remedy first before the State Administrative Tribunal. It is further submits that although the point of jurisdiction was not taken before the learned trial court, there is no bar in raising the said plea at the hearing of the appeal. It is undoubtedly a well-settled principle of law that the point of inherent lack of jurisdiction can be taken at any stage of the proceedings, as an order without jurisdiction is nullity. Para. Now the question is whether the plea that entertainment of the writ petition and passing an orders adjudicating the same was a nullity can be taken at this stage when the plea of jurisdiction was not raised at the first instance. The answer is definitely no. It is now well settled. The existence of an alternative remedy is not an absolute bar to entertaining a writ application. When there is existence of an alternative remedy, the writ court may exercise some self-imposed restraint in entertaining a writ application or may entertain the same in the interest of justice. The position is slightly different in case of administrative tribunals which are constituted to adjudicate the disputes with regard to recruitment, promotion, transfer, service condition and retirement benefits of government employees, whether state or central, where administrative tribunals are already constituted. Government employees are to exhaust their remedy before the tribunal at the first instance. So only in a very case can the High Court entertain a writ application in service matters where an administrative tribunal is constituted. For example, when a tribunal is not functioning for a long period and a state government employee has an extremely urgent matter, a High Court can exercise its inherent powers under Article 2 to 6 of the Constitution of India. It is to be remembered that when a suit is brought under a particular provision of a statute, civil court has no jurisdiction to entertain the same, but when a statute provides an alternative remedy for redressal of dispute, it cannot be argued that writ petition is not maintainable. It is only when the respondents against whom writs is sought to be issued is not a state within the meaning Article 12 of the Constitution of India. The plea of non-maintainability of a writ petition can be taken in the instant matter. It is not the case of the respondent authority that the said authority is is not stated under Article 12 of the Constitution of India. It appears from decisions relied upon by the learned advocate for the state respondent that in the said writ petition regarding hostel employees of government polytechnic institution, the plea of non-maintainability was not taken before the Honorable Division Bench of this court, and the Honorable Division Bench was pleased to adjudicate the matter and laid down a proposition of law. Thus, when a proposition of law is laid down by Honorable Division Bench of High Court as well as Honorable Special Bench on reference, it would be reasonable to decide the issue on the proposition of law laid down by the Honorable Special Bench upon considering the facts of the present case without referring the matter before tribunal after a period of 8 years from the date of disposal of the writ petition. Thus, I am of the view that this bench should dispose of the issue involved in the writ petition by deciding this appeal parachain. On the argument of Mr. Mukherjee, learned advocate for the state of West Bengal, that the trial court in this case and the Honorable Division Bench of this court in the case of Director of Technical Education and Training, Government of West Bengal versus Chunilal Chakraborty, came to a findings without considering the ratio in the case of the state of West Bengal versus Povir Chakraborty reported in within bracket 2007 3 Cal LT 545. It is necessary to consider as to how far the decision in the case of within bracket the state of West Bengal versus Povir Chakraborty is applicable to the facts of the case pair. The Honorable Division Bench of this court in the case of state of West Bengal versus Povir Chakraborty within bracket Shupra held that cooks and helpers in the hostel of Raiganj Polytechnic could not be considered as Group D employees of the college. However, as the Honorable Division Bench hearing FMA 2680 of 2007, FMA 2681 of 2007 and MAT 2903 of 2005 within the state of West Bengal versus Govardhan Duloi and others did not agree with the decision of the Honorable Division Bench in the matter of state of West Bengal versus Povir Chakraborty. The matter was referred to the Honorable Special Bench para. Upon considering the decision of the Honorable Special Bench, the state government adopted a policy of granting Group D status to the hostel mess employees and to treat them as Group D employees of polytechnic colleges. The Honorable Division of which my brother was a member in the Chunilal Chakraborty case, upon considering a note sheet dated 21st November 2014 signed by the Director of Technical Education and Training, Government of West Bengal for implementing the policy of granting Group D status to the hostel mess employees and to treat them as Group D employees, appealed the decision of the learned single judge, where the learned single judge opined that since the employees of the writ petitioners were doing the same type of work as the canteen employees of the state, the writ petition should be allowed. The special leave petition filed against the order passed in the case of Chunilal Chakraborty also stood dismissed. The state of government has complied with the order of the division bench by granting the status of Group D employees of Polytechnic College. Thus, there is a difference in circumstances between the Povir Chakraborty and Chunilal case. Hence, the decision in the matter of Povir Chakraborty within bracket Supra is not applicable. In the facts and circumstances, I am of the view that there is no merit in the appeal and the same should be dismissed pending connected application, if any is also disposed of. Certificate photocopy of this order, if applied for, be supplied to the parties upon compliance with all requisite formalities. Stop. Thank you. Jai Hind, Jai Mera Bharat. Chakraborty also stood dismissed. The state of government has complied with the order of the division bench by granting the status of Group D employees of Polytechnic College. Thus, there is a difference in circumstances between the Povir Chakraborty and Chunilal case. Hence, the decision in the matter of Povir Chakraborty within bracket Supra is not applicable. In the facts and circumstances, I am of the view that there is no merit in the appeal and the same same should be dismissed pending connected application if any is also disposed of. Certificate photocopy of this order, if applied for, be supplied to the parties upon compliance with all requisite formalities. Stop. Thank you. Jai Hind, Jai Mera Bharat. Compliance with all requisite formalities. Stop. Thank you. Jai Hind, Jai Mera Bharat.